Hi, everyone. My name is Leslie Pang Dykeman, and I am the paralegal on the probate team at Open Door Legal. And I will be your presenter today for the estate planning information session, where we will learn about various estate planning documents that we help folks to prepare. Before we begin, I just wanted to take a moment to let folks who may be new to Open Door Legal know a little bit more about the work we do. So, Open Door Legal is a nonprofit legal services organization with the mission of providing free legal services for all viable civil legal claims and defenses for low income residents located in our San Francisco service areas, with the ultimate goal of reducing poverty. And you may be first contacting us for estate planning services, but we have represented clients in more than 35 areas of civil law, such as divorce, child custody, bankruptcy, personal injury, small claims, immigration, tenant rights, housing issues, employment issues, and many more legal issues that people face in the communities that we serve. And also, a few things to be aware of before we begin. First, this is a group or public setting, if you will, and there are other people in the audience, and we cannot ensure your confidentiality here. If you have any questions or you want to ask about your situation, please save them for the end where we can go into breakout rooms or save them for our initial intake meeting in the office. But it's probably a good idea if you get a notebook and a pen or some kind of writing utensil to write down your questions as you're listening to this presentation. And the second thing is this presentation is meant to be a general overview and does not contain any legal advice. I am not an attorney, and and only an attorney can give you advice about your personal estate planning needs. And because there's no legal advice being given here in this presentation today, there's no attorney-client relationship being formed. Therefore, we aren't checking for conflicts. That is, if we have previously represented or are currently representing anyone who may have interests that are different than your own. So, before we begin talking about estate planning, it helps to understand what an estate is. And a lot of people assume, for some reason or another, that estates are only for rich people or people who own a lot of assets or property. But actually, anyone can have an estate. An estate is simply property that you own when you pass away. And that the property can be real or personal. And when I say real, it means things that are attached to land or the land itself. So it could be a home or a building or just like a land, like a ranch, or a share of a cooperative. And personal property, it could be things that are tangible, like jewelry, clothing, furniture, vehicles, or intangible things like bank accounts, stocks, bonds, Bitcoin. It also helps to think about what happens if you pass away without a plan. And in California, the intestacy laws will end up determining who your beneficiaries are, even if you didn't intend for them to have your property. So if you have a really good friend that you wanted to receive some of your property, they would not receive anything under California law. It would go to your next of kin. And if you wanted your grandchildren to inherit instead of your children, the California law would not provide for that. And then also, if you end up having minor children, then and you didn't have a surviving parent, then probate court will end up choosing who your next guardian of your children will be. And then finally, your estate may have to go through probate court, which costs time and money for your loved ones. And when I say may have to go through probate, there are a lot of factors in which determine the need for probate, which we will cover later. And on this slide, these are the four most common estate planning documents that we prepare at Open Door Legal. And that's a will, a living trust, a durable power of attorney, and an advanced healthcare directive. If you're not familiar with these documents, we'll dive into them a little bit more in this presentation. So we'll start first with the will. And a will is a document that directs who will receive your estate when you die. Those people are called your beneficiaries, and the person who will manage the process once you pass away, and that person is called your executor. And your executor and your beneficiaries can be the same person, and often people choose among their families and in particular their children. If they have one child, that child can be the beneficiary and also the person carrying out their wishes, the executor. And then in your will, you can also nominate the legal guardian of your minor children, if you have any. There are various benefits and limitations of a will, and we'll start off with the benefits. You can control who receives your property rather than leaving it up to state law. You can also, again, choose your own executor who will manage your will, and a legal guardian rather than having a court figure out who to appoint. And you can avoid probate court, but only if your estate is under $184,500, if it's under this threshold, which brings us to the limitations. There's this threshold of $184,500. If your estate is over this amount, then your will or your estate may be subject to probate. So when I say may, I mean that there are assets called non-probate assets, which are property that passes outside of the will. Um, and I mean that those assets can be claimed by the beneficiaries without the involvement of court. So those excluded assets are things that are owned in joint tenancy or as community property with the right of survivorship. And some assets that can be owned that way are your house or a bank account. So if one owner dies, the other or the others can assume ownership of that asset. The other assets that aren't included or are non-probate are assets with designated beneficiaries. And those could be things like your life insurance policy or your retirement plan or pension plan, but also can be something that you actively put on, like for a vehicle, for instance, a transfer on death beneficiary, or for a bank account, a payable on death beneficiary. And finally, things that do not go through your will are assets that are held in a living trust, which brings us to the next slide. And that is a living, it's also called a revocable trust. And that is an entity that is set up and funded by you as the truster, and that allows you as a trustee to control your assets during your lifetime. And you can think of a trust like a safety deposit box that you can open up at a bank. The truster is you, the person who decided to open that box, and whose valuables are inside the box, hopefully. That's the funding part. The trustee is also, again, you during while you're alive, since you're the person who will have the key to open the box and take things in and out. So when you pass away, you get to nominate who becomes your successor trustee. And that person is going to be managing the property that's in the trust or in the safety deposit box. And they will also be distributing the property to the beneficiaries that are named in your trust. And a successor trustee and a beneficiary can be the same person. A lot of times, people, they have children and they want to choose among their children. And we just wanted to highlight here that you can choose somebody to be in the role of successor trustee, and that person can be um, managing your trust property and making sure that the property gets distributed to the beneficiaries, but they can also be the ones receiving the property at the same time. And another document that we prepare with the living trust or the revocable trust is a pour over will. And it works together with your trust, and it acts like a safety net in case you forget to properly fund or transfer your property into your trust, in case you forget to put the valuables into your safety deposit box. So there are benefits and, of course, limitations of trusts. We'll start with the benefits. And one of the biggest benefits is you can avoid probate court if you own a home. If you think about it, a home in San Francisco probably goes for around close to $1 million now, for a single family residence. So if you are a homeowner, you most likely will need a trust. And another benefit is that trust is administered outside of court supervision, and that means that your affairs won't have to be going through the probate process, which is those cases are all viewable by the public. And same as benefit with a will, you can control who receives your property. And then a little bit, and unlike a will, your successor trustee can actually take over managing your trust if you become incapacitated. And if you don't know what incapacity means, it could be a situation where you're in a coma and you're alive, but you're not able to. Take care of your own financial affairs, for instance, or you can't go and make the mortgage payment, things like that. So your successor trustee can take over managing your trust in that situation. And then another benefit of having a trust is because you're keeping your assets out of probate court. In probate court, you have to notify Medi-Cal or the Department of Healthcare Services. And if you were a Medi-Cal recipient, they can make a claim on your estate. So through probate, through that probate notice process. And again, because your trust is administered outside of court, you get to shield your assets from that. And there are limitations of trusts, namely that a trust must be funded. So if you're having trouble understanding this concept of being funded, you can think of funding. If we go back to the analogy of when you open that safety deposit box, putting your valuables inside that box, that's called that. You can think of that like funding. So when you create a trust, you do have to fund and put assets into the name of the trust. Um, and so basically, a trust is a very complex document, and you may want to get the help of an attorney to set it up and properly fund it and understand how to use it as a tool. Um, and Another limitation is that, again, it's not supervised by the court. And sometimes when there's a lot of people butting heads, maybe people want that court supervision, that judge who's supposed to be neutral to, you know, oversee the process. And then because oftentimes people want to get help from an attorney to set up a trust, it can be quite costly to create rather than just creating a will. And if you have to hire a private firm to create a living trust for you, that could start upwards of like starting from $3,000. But hopefully, Open Door Legal can help if you are eligible for our services, because all of our services are free. Which brings us to our next document, which is called the Power of Attorney, or DPOA for short. And this is a document that gives another person called your agent the power to make financial decisions about what happens to your property, if you get sued, and other financial issues. In this document, you can also select which powers to grant, namely, you can choose whether or not to give them the power to access your bank account, to give them the power to buy or sell property for you, to file taxes for you, or to make any other financial decisions. And this document can be springing upon your incapacity. Once again, that just means like a situation where you're no longer able to act for yourself, for instance, due to being in a coma or being hospitalized, and you're alive, but you are not able to manage your financial affairs. Or it can take effect immediately upon signing. So some people might want to create an effective immediately power of attorney when they're traveling overseas for a year and they have a spouse that they want to give this power to make decisions about their property, to be able to file taxes on their behalf, things like that. And this avoids the necessity of what is called a conservatorship of someone's estate, which a person would have to go to petition the court for, and it's going to cost them time and money. And the last document that we usually help people prepare is called an Advanced Healthcare Directive, or an AHCD. And this is a document that gives another person, also called your agent, the power to make healthcare decisions for you. So this is like a medical power of attorney, a medical decision maker for a situation where you yourself are not able to. And again, this document can be springing upon your incapacity or effective as soon as you sign. And in this document, you can select the end of life care that you want, such as, do you want life support? Do you want pain relief? Do you want to pursue treatment, even if the outcomes, the risks outweigh the benefits? Things like that you'll have to reflect and think about. And after you pass, you also have a say in what happens to your remains. So, do you want to have an autopsy? Do you want to donate any organs? Where do you want to donate them to, if you want to say? And this avoids the need for a conservatorship over your person, which is something someone would have to petition the court for if they can't themselves, don't have the authority to make decisions for you. And that again costs time and money. So, in summary, why should you make an estate plan? It's usually a good idea to have things in writing, as lawyers always say. But some reasons that I've heard of and that we've covered in this presentation, I'll start off with the first one that you're seeing at the top, is you can maintain family harmony. If you have a lot of family members who might each have a different opinion or understanding of your wishes, putting something in writing can often offer clarity in a time where maybe you've lost incapacity, or that you passed away. You're not there to speak for yourself. So putting something in writing while you can might help people settle some disputes. And you can also avoid probate court, which is something that we really try to highlight at Open Door Legal. Probate court is costly, it will take a lot of time, It's not a fast process. And if you don't have a will, your estate will need to go through probate. So it's often a good idea to make some kind of estate plan. And also, we never know what's going to happen to us. So right now we might be okay, but then maybe, tomorrow I get hit by a car and I end up being in a coma. So there are these documents. Again, those are the durable power of attorney and the advanced healthcare directive that address potential future needs, such as, a, a time or a day when you become incapacitated. And you'll be prepared because you will have this document where you've nominated who you want to manage your finances and your medical decisions when you won't be able to speak for yourself. And something that we also highlighted in the presentation is maintaining control over who you want your property to pass to, um, and not leaving it up to state law, and keeping your affairs out of the public eye, since probate court, the cases there are viewable to the public. And that is the end of our presentation. Thank you for joining me on this estate planning information session. There are some next steps for you to do before you come back to us for your one-on-one appointment in the office, and that is to complete the estate planning questionnaire. Hopefully, you've already received one when from the front desk when you booked this estate planning information session. And it should be a questionnaire that asks you who you want your executors or trustees to be, who you want the beneficiaries to be, who you want your power of attorney agent to be, and who you want your advanced healthcare directive agent to be. So, those are all the things that hopefully this presentation has gotten you to think about, to start reflecting on. And you'll need to complete that questionnaire before you call our front desk. You can think of it as a ticket to book the appointment, if you will. And there are a couple things that I want to mention here that you should know. So, if you are under 50 and in need of a living trust because you're a homeowner or you have a large asset of some sort, we will need to refer you. Unfortunately, we don't have the capacity to serve everyone yet. So, our cutoff is age 50 for living trusts only. But if you are in need of just a will, power of attorney, or advanced healthcare directive, and you're under 50 or you're over 50, we're happy to help speak with you about that. And um, another thing to mention here is that we'll only need to meet with the person who is in need of the estate plan. And some of you might be joining with a family member today or a friend, and you might also want to bring family or friends to the appointment at our offices. But unfortunately, we'll be only meeting with the person who's creating the estate plan. And we'll ask anybody else, any other third parties, to wait outside. The only exception is if you're thinking about asking your spouse or your domestic partner to join you in your appointment. That would be a separate procedure, but that would be the exception. And the reason for that would just be if we have any other third parties involved in the estate planning process, that might jeopardize the validity of the documents. So that's why we will need to just ask other people to wait outside or come back to pick you up. And that's it. Thank you for joining me once again. My name is Leslie Pang Dykeman. I am the paralegal on the probate team. I hope to see you in the office for our meeting. And just one more thing, if well, this presentation is ending now, but please stay on to meet with whoever's hosting this presentation, hosting the meeting appointment with you. There might be a breakout room after this where you can have your questions be answered about your next steps, so on. So please stay on. But for now, I'll be saying goodbye.